Buonasera a tutti. We are so many that I cannot see everyone. So we are here with the America-Italy Society of Philadelphia and a successful partnership that we are bringing on with Italiza and Mignacca Law in Rome. Welcome. And tonight we would like to speak to you about a little bit more about the situation of the citizenship law in Italy. But first, I would like to give you just a couple of words about what we do at the America-Italy Society of Philadelphia. We do several things. We pretty much bring the culture and the Italian language to the United States. So we do cultural events. We have established school of Italian. We also do study abroad of 1 week of language course. We do partnerships, and tonight is one of those partnerships. And we also do advocacy for the teaching of Italian language in K-12 schools. We just created, because of the big interest that we are seeing around, a citizenship page, which with everything that we do, in the environment of citizenship. The America-Italy Society is an official location for CILS exams, which are the official exams for the Italian language accreditation. And very soon we will also get the CELI exam. To do that, we also prepare everyone who's interested with their level of Italian to get to the level to take these exams and pass them. We also do translation services, and for legal services, we partnered with Italiza and the Mignacca Law, who are kind of the overlap because they've been founded by the same lawyer, Alessandro, who's here tonight with us. Our school has right now 51 courses, active courses. We have more than 20 teachers, and right now we have 330 students. So we are well established. We have an amazing staff, amazing team. So if you're interested in learning Italian, that's where you should go. We do 70% of our courses online, so that's also possible. I already spoke to you about the two official exams where we are a location for, the CILS through the University of Siena and CELI through the University of Perugia. Now, let me actually introduce to you all Avvocato Alessandro Mignacca. Avvocato means lawyer, and Alessandro Mignacca is registered with the Bar Association of Rome and of Madrid. He studied law at the LUMSA University in Rome and did an important study abroad experience, which is the Erasmus European Study Abroad program in Spain, in Madrid. He also earned a master's degree in European private law at La Sapienza. It's the main university in Rome. And also second master at the Carlo Arturo Ierolimo Forensic Institute of Rome. He then also got at an America Common Law System and Comparative and Civil Litigation, an LLM, by the Temple University Law in Rome, because Temple University has a location in Rome too. He is also the supervisor of the course Latin American and Legal System of the Luis Guido Carli. It's a private, very prestigious university in Rome. He has 10 years of experience in private international law, and particularly in the field of immigration law. And this is why tonight we have Alessandro speaking to us. We are going to do something special. So Alessandro will be speaking, but also Pietro, who works at the New Jersey location of Italiza, will be presenting as well. So both of them will present and go through the webinar. As for questions, since we are over 100 people present, which is wonderful, but we will not be able to answer questions personally. So everyone is welcome to type questions in the chat, and Pietro will select some questions that will be addressed. But then for anything else, you're all welcome to write Italiza or Mignacca Law for your personal questions, and then we'll address them. You will have their email address at the end of the presentation. So now I will stop my PowerPoint and I would like to go back to Alessandro, who's going to project his PowerPoint.
Okay, at first, thank you everybody for your attention, and Elisa for your wonderful introduction. For us, it's a pleasure to stay here with you guys and can show what's the decree law, the new law bring to all the Italian descendants. So I'm here with Pietro too. He's responsible of Italiza in New Jersey, and start with us that presentation about something detail about the decree law and the implication and the solution for each case, maybe. Okay, so the new rules of Italian citizenship is understanding by Decree Law 36, 2025. And the Decree Law bring some very pointed situation different from the law before staying in action. So the 91 of 1992. So maybe Pietro can start to introduction the new law, and then I complete each point maybe to be helpful. Okay, Pietro, go ahead.
Yes, good evening, everybody. Buonasera a tutti. My name is Pietro. As Alessandro and Elisa mentioned, I represent Italiza here in the New Jersey office. So just to introduce the new law followed by the decree specifically. Decree law number 36 of 2025 was converted officially into law just about a week ago on May 20th. The nature of this change is that it is not a comprehensive new citizenship law like those of 1912 and 1992, which you might be familiar with. It acts as modifying parts of the law number 91 of 92, which still currently remains as the main citizenship law.
Yeah, this is important because we see not a completely new law, but the citizenship in our history. We got three different citizenship law. The first was in 1865 after another change in law. Specifically for the citizenship law was in 1912 and after in the 1992. So in that case, the decree law is not a new law about citizenship, but only change something rule for who born abroad, but stay in the same rule of 1992.
So to get into sort of the bones of the new law and exactly who is eligible currently and what implications the new law has imposed, one of the most important points is affecting people born abroad of Italian descent, specifically in this case. Individuals born abroad under the new decree under certain criteria are no longer eligible for citizenship as long as they were born outside of Italy. This law is retroactive, meaning it applies to those born both before March the 28th, 2025, when the decree was introduced, and those also born after the decree was introduced. Why this is important is that the law does act retroactively, which I will pass the ball to Alessandro to explain a little bit why that is a little bit peculiar, based on the Constitution of Italy as well as legal precedents through the courts.
Yeah. What's happened in the last citizenship law was that the most important part was all the right gained before the new law, they are preserved. So each citizenship law work only for the future. For this is the first time in our history where the government apply a decree law, and here we need to understand a little bit more about that measure. The decree law is a pending measure that is a public and at the same day have effectiveness. So they deserve to be converted by parliament in no more than 2 months. But the ruling, the action of that new decree law start when they publish. So the government publish it. So March 28, 25. For the first time, so we have retroactive action for the right gain acquired before. And this is important because that the first sentences is very particular, is something too strange to hear something like that, like individual born abroad are considered never to have acquired Italian citizenship. So they said, we're going to derogate what's happened in the last citizenship law, but at least is nothing more that disagrees you lost your right, because you gained that right when you're born. And this is the focal point of our presentation, and we will going to see it after, for understand which is the critical point about law, which what they can use that unconstitutional vision for new application.
So here are some exceptions or criteria where people would still fall under eligibility. The first being recognition or an appointment. Citizenship status was already recognized, whether that be through a consulate or through a municipality, or an application or documentation were already submitted, or an appointment for a citizenship application at a consulate, for example, was scheduled before March 27th of 2025. Now, Alessandro, can you explain a little bit the point about the appointment at the Italian consulates, which might not be that clear?
Yeah. Well, when we're talking about the focal point is all right, we have the possibility to doesn't more be Italian only for the fact in the past to born abroad. Then the decree law bring us different criteria. The first is who already bring the document and sign the request to become an Italian citizen. And at the same time, they change, because when the decree law start, they produce a text, but after pass the ball to the Senate and the Parliament, and the Senate change something through the amendment. One of that amendment is join the meaning of the appointment. So if you have a consular appointment or municipal appointment, if you are residential in Italy, so in your municipality, you are safe too. But the appointment here is meaning like the individual date, place, and time to bring the document and sign the request. So everybody who stay in the line in North America and South America is an incredible number of people who are in the waiting list. All of them lost the possibility to be recognized like Italian down that new decree law.
So moving on to a judicial action, which a lot of people, especially in South America, do choose to go through. If citizenship status was judicially confirmed via a case filed before March 27th of 2025, when the decree was introduced. Now, Alessandro, if somebody filed a case or had an attorney file a case on their behalf before March 27th, they would still be safe under the old law, correct?
Correct. So that the decree law changed the very more principle and fundamental principle in the European, international, Italian right, but one of them is preserved down that decree law, so the effectiveness of the rule. So if you start an action and the day after change the rule, the law, you are safe. So in that case, the preserve who stays in a judicial action proposed before 27 March 2025, that people are safe, so they can wait in safe way the finish and the ruling of the judge to recognize their citizenship.
And going on to point 3, probably one of the biggest changes to Italian citizenship, which was once without generational limits, the implementation of generational limits to a parent or a grandparent who is also exclusively Italian. Alessandro, can you explain this point, what the generational limits entail, and the naturalization and citizenship status of the parent or grandparent?
Yeah, we can talk about the point 3 and 4. So we continue here the iure sanguinis. So they bring the citizenship by blood for the family, and so the descendant in that case only for the second generation can bring and can give the possibility to the descendant to recognize the citizenship, but we have here two different criteria, alternative criteria. Or the grandparents or the parents are exclusively Italian. That means that, of course, nobody who born abroad, because if you born abroad, for example, in the United States, you gain the American citizenship only for the fact you born there, and it's the same rule in the South America or in Canada. So in that case, this is one of the more critical part of the text, because the original text saying about the Italian who born in Italy, but in that case say about an Italian who have exclusively Italian citizenship. And the point 4 is an alternative criteria. That criteria is if the parents or grandparents legally live in Italy like residential for 2 or more years before the child's birth. So in that case, maybe in the United States, there are interesting group of people, other people who stay down that second and last situation of the criteria in the United States.
I think the slide presentation needs to come back.
That one?
The slide presentation, I think, is off, right? I don't see it. Pietro, do you see it?
No, Alessandro, I think the screen sharing turned off.
Yeah.
All right. Okay. Right now? Yes? Can you see it?
Andava benissimo prima.
Okay. All right. Some moment.
So into one of the next points here, which definitely a lot of people are interested in learning a little bit about, foreign or stateless minors, children, grandchildren of Italian citizens or people who acquired Italian citizenship. So one thing that I would like, Alessandro, for you to describe a little bit is now how citizenship is acquired now by benefit of the law and not by birth as it was previously.
Yeah, so the minor who are not in the case of the both criteria by the blood before explain it, they are able to be Italian, but is not they are not born like Italian, but the father or mother can produce a declaration in the consulate for give those to those minor the benefit of the law to be Italian. It's like a naturalization. Is not an original right. It's a right who start when the declaration arrived to the consulate or in to the municipality. And in that general rule say, at first, all the minor who are children from an Italian who are not down the 2 category. So, or we have exclusively the Italian citizenship, or live 2 years before the children born, so they can bring till May 31st, 27, the declaration to recognize or to acquire the Italian citizenship to the minor. And another rule after that period, that deadline, so if it is possible to produce a declaration only if the children live in Italy 2 years before declaration, or if they have only less than 1 year. Okay, so this is important because we produce here another category of Italian, and that decree law produce different categories. So we will see a different categories. So each category need to produce different manifestation of will to become Italian. And it's interesting because they put a little tax for acquired the citizenship for the minor who gained the citizenship by benefit of the law, and that cost is 250.
So to get back into a different point of acquiring citizenship for a minor child. Now, a minor child who is declared Italian and holds both Italian citizenship and perhaps another citizenship, if they were born on U.S. soil, for example, does have until they are adult age 18 to renounce their Italian citizenship. Alessandro, could you explain, what are the legal reasons for this, even a historical context for renunciation once a child who was given citizenship turns 18?
Yes, because this is the reason why the minor who acquired by a declaration by the father or the mother and not by original title, they can renounce to Italian citizenship when we reaching the adulthood. This is important because they put some different way to gain the citizenship and different way to renounce to it, and this is important for the children of that minor who give the citizenship through benefit of the law, because the children of that right now minor can acquire the citizenship only if they are residential in Italy. So at least the decree law stop the citizenship in the second new generation in the future. Okay, the only way to become Italian for the children who become citizenship by benefit of the law is residential in Italy for continuous 2 years, or since birth if the children is younger than 2. Since birth is meaning at least residential since birth is meaning you born in Italy. Is another way to explain that you must to born in Italy, but they can use it because it's become a iure soli and not more iure sanguinis, so not more citizenship by blood. It is important that that kind of declaration indicated in that decree law must to wait. We must to wait the guideline from the consulate and the Ministry of Interior, and some consulate already in this week published the declaration, the draft of the declaration for the minor.
So this is a topic that might interest definitely a lot of people in the U.S., especially for reacquisition of citizenship for people who unfortunately lost citizenship of Italy due to U.S. naturalization. So, of course, those born in Italy with U.S. or Italian citizenship and who resided there for at least 2 consecutive years and lost citizenship under the provisions of the 1912 law would have an opportunity to reacquire citizenship. Alessandro, can you explain how how you would reacquire citizenship and also an important point on the limitation on the transmission to children and grandchildren, for example?
Yes, we see the same situation in the 1992, because the law 1912 saying if you get another citizenship down a manifestation of the will to get another citizenship, you lost the Italian one. In the 1992, the new law of citizenship in Italy opened to more citizenship for it for the Italian descendant, and in that and the Italian already Italian, and in that case is nothing more that open another window through down that new decree law for 1.5 years. But the point is limitation of transmission, because they can transmit the citizenship only if the children of that new Italian who reacquired the Italian citizenship is still a minor, as is possible, but it's quite difficult to be possible. And in that case, so they at least said, okay, you can continue your own life like Italian, but you can pass to the new generation. And in that case, still the cost is still 250 to pay to the Ministry of Interior in Italy.
And Alessandro, just to point out maybe a personal example for some people that might be in the webinar tonight. If somebody immigrated to the U.S. perhaps in the 60s or the 70s, and then unfortunately became a U.S. citizen before 92 and then lost their Italian citizenship, and have children and perhaps grandchildren that the children, of course, are over the age of 18, they would unfortunately not be able to transmit Italian citizenship to them and their grandchildren, correct?
Correct. Yes, exactly. The only way is if they are still Italian or exclusively Italian citizenship. This is the only two criteria for that. So, okay, we can continue.
So who is not covered, essentially, who is not eligible any longer for Italian citizenship? Those not included in the categories listed and discussed above, including those who applied or attempted to apply via consulate, whether that was to make an appointment or even gather some documentation. These applicants are unfortunately not considered to be Italian, or as the decree text describes explicitly, never acquired Italian citizenship. Alessandro, can you explain a little bit more about the original text and perhaps some possibilities, not to jump too much into legal stuff yet. I know it's going to be covered quite shortly, but if you could just give a quick overview on this point.
Yes, at least this is a very small and short decree law. Only introduce something different point about who born abroad, and this is the point in the critical point. So everybody who stay in the situation to born abroad, but note down that 4 categories, so 4 criteria, they are not more considered Italian. And this is important because the original text seemed the original text used improperly language to disguise the loss of citizenship, because the individual who already had the legitimate to write it, and at the same time, when you born, you get your citizenship. So this is important down the vision of Italian jurisprudence down there. The last opportunity to see it is only 2 years ago, when the Supreme Court ruling, his name is Corte di Cassazione, is the 3rd level in civil court in Italy. In the case of the Brazilian great naturalization, and we had the opportunity to defend and be one of the part of this case, our Supreme Court remarked the position of the old Italian board. Because in that case, for example, in Brazil, in the 1889, when the Brazil became republic, declared that everybody who stayed in that position, so in Brazil, have the right to become a naturalized Brazilian. But in that case, the second citizenship, meaning you lost Italian one. In that case, the Brazil apply a law without the manifestation of the will for the Brazilian to get another citizenship. And this is the meaning that it's impossible to lose your citizenship if someone, including the government, apply that unilateral disposal. So in that case, the principle that our Supreme Court say is citizenship is acquired from the birth, and this is permanent, imprescriptible, and we can assert in the court at any time. So the difference here is the right to gain in substantial acquisition when you born, and the formal way to recognize it, through a judicial way or through an administrative way in front of the consulate or in the municipal here in Italy, if you live in Italy. This is very important because the lost automatically, the citizenship is absolutely unconstitutional. And the court affirmed that is automatic unconstitutional legitimate loss must be result to a conscious and voluntary act. We have another precedent for the women, Italian women, because as our constitutional court in 1975 and declared unconstitutional a part of the old law 1912 in the part which provide that the women lost the Italian citizenship without manifestation of the will, but for the only fact that married a foreigner. So this is exactly the same situation. So when we're talking about constitutional issue, we can see that the new decree law is completely against the article number 3 of our constitution, so equality principle, because it's discriminatory. At first, it's discriminating for against who acquired another citizenship, because the law of 1992 opened the possibility to get another citizenship. And this is discriminatory for who stay in the list in the consulate. I talked with a girl who stay in Abu Dhabi a month ago, and in Abu Dhabi are not descendants, Italian descendants over there. So she bring the documentation and signed the request at the same day, and after 4 months, she became Italian. So is a completely disparity of treatment for the same people who have the same right for stay down a consulate or another, only for the problem inside the organization of that consulate. So it's completely discriminatory. And we have a strange situation, for example, for the sibling in the same family where the parents are Italian, recognized like Italian, but are not included in that 2 criteria. And one of the children get inside for example, judicial case. We have a lot of cases like this. And they give that minor, it will be recognized Italian by board. Right now, the second children start to the declaration, but give the citizenship only by benefit by law. So we have different treatment between the 2 siblings, because the first one can recognize the children, and the second one necessary need to that children residential by born in Italy or live 2 years in Italy. So it's completely disparity. Another constitutional issue is about the Italian constitution, the Article 22, because inside our constitution is defend the citizenship. So no one may be deprived for political reason of legal capacity, citizenship, and name. So in that case, we're talking about political reason in open vision, because we are down a clear strategy of our government to cancel all the citizenship for who born abroad before, and so enter in that situation. It's interesting because we have here a relevant fact about the question of constitutionality, because only 8 months ago, Bologna court, in a case about the grandchildren, asked for the our constitutional court if the people are included in the that people are included in the concept of the people, so who have effectively relationship with the country. So in that case, we need to waiting the constitutional court ruling, and the first meeting happened in 24 June of 25. But we can see that the constitutional court is fast for understand which is the point. So the pathway to challenge in law down the constitutional court is by a judge. So a judge can understand if we have a new situation down that decree law, and the lawyer can ask to the judge, and that judge's name is a quo, can issue a question, constitutional question in the court, and the court maybe in 8-10 months can decide about the inconstitutional way for how the decree law work. It's important here because it's possible that 24 June 25, our Supreme Court explained to us and to the judge, in that case, Bologna judge, that the new decree law maybe is unconstitutional. So no waiting another issue in front of the Constitutional Court, but can include it for that case, maybe a pronunciation about the new decree law. This is important, the overview of the meaning, not only in Italy, the interpretation of our Supreme Court and our Constitutional Court, but we have implication in international and European law. At first, we have the Universal Declaration of Human Rights. Article 50 said, no one shall be arbitrarily deprived of their nationality. And in that case, the decree law, nothing more do than not deprive all the Italian descendants born abroad, deprived of their nationality. But there is another point here, is the European case. Because in Europe, when you are part of a country who stay in Europe, you are at the same time get the nationality of your country and the nationality of the Europe. So in that case, you are down the Article 20 of the treat for the function of the European Union. And in that case, the Article 20 included the Article 7, that's meaning that each law about the citizenship of the member state, so at the same time to the European Union, need to be down the principle of proportionality. So they deserve, if the member state want to change something, they deserve apply a period for the citizen who going to lose the citizenship to claim that citizen, and not for the night to the morning, the morning after, like the decree law works for loss the citizenship. We have a president. It's very interesting for us because they open a very grateful scenario, because the European Court of Justice ruled similarly in the Danish case only in September 2023, where the Denmark opened a new law where the Denmark people lost the citizenship by decree if they born abroad and they never claimed the citizenship till the 22 age. So in that case, we have a clear situation where the Court of Justice in Europe blocked that new law and opened the possibility for the Danish people who live abroad to claim in that deadline their citizenship. The pathway to challenge in a European context, so going to European Court of Justice is more or less the same. So at first we start a claim with the judge, and the judge asks for the European Court the preliminary question against the Article 20 of the Treaty of the function of European Union. In that case, the difference is the court deserve more time, at least 1 year and a half for the decision.
And just before we close up on this last point, I've seen a couple of messages already in the chat that I think we should speak about briefly. The first thing would be, Alessandro, the minor rule, the decision of October of last year, which forced many people to become ineligible and not be able to go to their consulate appointments, which were already booked. Could you explain a little bit the decree and its relation to the minor rule decision?
Yeah, that decree law only, when we're really talking about, only change a specific point for who born abroad, but the law continue be the 91 of 1992. So for the minor rule, we are in the middle of a question in the Corte di Cassazione, so the high level our Supreme Court, and we waiting for the decision. We know that the governmental party, the defensor of the states, express a point of view interpretation against the minor rule, and this is easy because the minor rule start down another decision of our Supreme Court in April of last year, 24. But in that case, the father become a U.S. citizen in 1910, and only in 1912 the minor rule can start to operate it down a specific article in that new law, so the law of 1912. And the Minister of Interior apply of course, by blocking way to all who stay in the minor rule. Probably we change the situation down the minor rule, but the decree law doesn't matter, doesn't enter in that case, and it doesn't enter in the maternal case too. We have the situation where the women can pass the citizenship to the children before 48, because only in 1st January 48 start our constitution, and that difference of gender is against Article 3 of our constitution. So in that way, we still continue in a maternal case if the women in that case is one of dead parents or grandparents and stay in that criteria. So, or leave 2 years before in Italy before the children's born, or have exclusively the Italian citizenship. So this is important to understand how that decree law work. The strategy of the government is clear, and they explain that strategy in the relation sending to the Senate and to the Parliament for explain that decree law. So they want to apply a completely and clearly unconstitutional decree law for blocked all the claims in the consulate and in the court. This is important fact, because in the court only in the 2024, almost the half of all claims in the court, Italian court, was down claims of citizenship by descendant, especially in South America. It's an incredible number, but that's it. So maybe the citizenship deserve a different law, but balanced law, specifically down the principle of European rights. So balanced. But in that case, they punish everybody at the same way, and in the same time, they produce a new proposal, a new design of new law for the citizenship, who going to derogate, to abrogate, to delete that law, the 1992, maybe even though with that new changing down that decree law. Is a little bit difficult to understand, but the planning is easy. Block it everybody, and after produce the right law down the principle of compliance to the European and and the international standard. So maybe the most important thing to do right now is claim and start a judicial case. Why? Because when the decree law and the probably that they declared unconstitutional down the Constitutional Court in Italy and down the Court of Justice in Europe. So if someone enter right now in the process before that new law was started down the parliament in Italy, so already who started the process right now are still down the old law 1992.
This is very important.
I don't know if I explain this point in the right way, Pietro. Can you produce a little bit of endorsement about that?
But just to clarify here, the future citizenship law is being drafted currently. The law did pass on the 20th and was then officially passed on the 23rd of May, which many legal experts and attorneys are expecting that the decree will be deemed unconstitutional. Between the time from when the decree was put into action and when that new law, the law that will most likely be constitutional and will abide by the Italian Constitution and European Court of Justice standards, the ability to initiate a court case between those two sort of events would allow you to fall under the old rule and still be eligible. For example, if you were a third or fourth generation applicant, who could maybe slip under the cracks in a certain way before the new law is produced.
Yeah, that's it. So Of course, they obtained the result because the majority of the descendants are screenly down that new decree law. But the first step we can see, 24 June, down the decision or the meeting with the Constitutional Court down more or less the same point. It is incredible because the motivation of the claim of the Constitutional Court down the Court of Bologna are almost the same for present in the relation of introducing that new decree law and the present to the Senate. It's a coincidence, but I don't know. I know believe too much in a in a coincidence.
So to conclude, and some next possible steps, the complexity of this new legislation requires careful attention and swift action, especially when given the timeline, preferably with the support, of course, of someone who is an Italian legal expert. It is also essential to analyze each case individually. Each case is different. Each naturalization of a grandparent or great-grandparent is different, and maternal and paternal cases can prove to be different as well, and the new implications of the law can affect future cases. Mignacca law in Rome and Italiza as well here in New Jersey are available to efficiently assist applicants and answer any questions and assist with any other possible concerns or questions you have with current or even future applications.
Thank you very much. That was very interesting, very complicated for someone who's not an expert. So we, as you know, we have a collaboration with Italiza. So our members, active members, if you decide and need some advice and legal services from Italiza, you will get a discount rate for our members. Now, Pietro, is there any question that we might want to answer that was in the chat that you think it was representative and everyone could benefit from it?
Yes, of course.
And then also the email address, but you also can find their website on our website, and yeah, sorry.
Correct. The first question we will highlight is from Ron Sienna. He mentioned, if I am eligible for dual citizenship through my paternal grandfather, can my children qualify for citizenship?
So in that case, we have clarified the situation where the grandparents at first need to be residential in Italy before your father or mother born, and at the same time, or have exclusively so never naturalized American. So this is important. I think this is the case because one of that criteria, both criteria, is applied in the most of majority of person in United States that are grandchildren, but your son, your children are not eligible in the new decree law. So it's not recognized by born like Italian, but only down a declaration. But that declaration can apply only if you require your citizenship before. And the point is, of course, you start your citizenship path through require in the consulate right now, but maybe the consulate doesn't concluding that procedure in 1 year. So if your children have more one year, and for sure it's happened, maybe you cannot do the declaration of him till the 31 May of 2026. So the best way in that case, for example, is start the process for your children too.
So the next question that we're going to highlight pertains to something we didn't touch on, but I think deserves to be touched on briefly is citizenship by marriage. Marco Giancroce mentioned, currently my children and I are Italian citizens. What steps do we need to take for my wife to gain citizenship? And I think this could also coincide a little bit with Elisa and her team at AIS Philadelphia.
Yeah, because that decree law doesn't change the position for the naturalization by marriage. But in the proposal of a new design of law, citizenship law, and right now that new design of law, that proposal stay in a constitutional room of first constitutional room in the Senate, talking about cancel the naturalization for marriage. We understand this is more unconstitutional than the new decree law and some aspect of the new decree law. So it's very difficult they pass because the part of the majority and the opposite in the parliament are completely against that. But for sure, it's important start right now to do that process. And yes, is already available. It's still available, the possibility, and you need to show at first regularization of your AIRE. So if you are residential abroad, you need to enter in the anagrafe degli italiani residenti all'estero, so the Italian who live abroad, the list of Italian who live abroad, and show the marriage certificate too in Italian language. And who claims, so your wife in that case need to show the birth certificate and at the same time the B1 level Italian language. So Elisa, for sure, you can help in that path.
And this is why we created courses ad hoc, so courses made exactly for people that want to approach the language with the objective of getting the B1 cittadinanza, which is the B1 level for citizenship through marriage. And then we are also location of official exams for that.
Yeah.
Just to touch on one more question, which I think is extremely important here. From Frank S. Let me just pull up the question again. The question was, do I understand correctly that each case has to be tried individually? For example, a ruling on one case will not apply to the law overall. Alessandro, in the context of a constitutional court ruling, would that constitutional court hold precedent over the lower courts?
Yeah, at least the decree law producing different category of Italian here, who have only one citizen, who have twice, who live in Italy, who lived in Italy before, the new minor that have benefit of law, but is the same like naturalization. And of course, is necessary to start the process in front of the judge, but only for preserve the right that you have acquired when you born. So everybody who born before 27 March 25 are born like Italian. So that decree law can change that thing. And of course, right now we stay down an article of our civil code, article 265. So you can go to the judge for recognize your familiarity and your the fact that you are children of your parents, and this is the same for each generation till the Italian one. So in that case, we have interest for act. This is very important for start a new process. If you have interest of act, the meaning is the translated in Italian is interesse ad agire. You can act for the only fact that you want to be recognized like a son of your father or mother, children of your father or mother, and it's the same for each level of your genealogical tree till the Italian one. So when we start the process, of course, we start to argue what happened in the constitutional case, our jurisprudential, what against the human right, what against the function of the European Union, and especially the principle of proportionality, because it is completely no proportional than new decree law.
Alessandro, do we have time for one more question?
I think yes, for one more.
One more question that highlights a
It's
point.
just almost 1 a.m. for him.
Just one more quick question. If a parent resided in Italy for more than 2 years before my birth, but the naturalization occurred before the birth, would I still be eligible? If you could highlight exactly the sort of the criteria of naturalization under the new decree law.
The naturalization, if your parents or grandparents get another citizenship, but they born in Italy and live in Italy for 2 years, and get another citizenship before 92, they lost, so they cannot pass that citizenship for the descendant. But if that naturalization arrive after 92, so they are still Italian, and because the 92 law open for more citizenship at the same time. So in that case, yes, if you are including one of that criteria, you are eligible, and your children, if is your parents, one of your parents, so the grandparents of your children is eligible too.
Perfect.
Okay.
Grazie ragazzi, siete stati bravissimi. Thank you everyone for being here. We hope we were able to give you a better scenario. Of course, don't hesitate to contact not me, them, for any question. And I just wish to see you at the society. So we are there for you guys, for also other more fun stuff, I would say. Grazie mille. Thank you, everyone.
Grazie a voi. Thank you to everybody, and especially to you, Lisa, that give us the opportunity to show. And we hope that it will be useful, understand more about that decree law. We are here for all your right. Okay, thank you very much. Arrivederci, grazie mille.
Grazie, arrivederci.
Grazie, ciao.
Ok. Benissimo.